De rechtbank.
All rise.
Neemt plaats.
Please be seated.
De zitting wordt hervat.
So the sitting has been reconvened and is now open. And first of all, we will have the prosecution for the opening statement, and afterwards we will have defense for Mr. Pulatov. We'll have the opportunity to make an opening statement as well. I've also got a report from Ms. Jagers, and there you said that the support team for victims might like to make a few comments about how that team was put together. I don't know whether you've received my answer to you. Good. It obviously has. Would you like to make most of that opportunity? Unfortunately, the interpreters are unable to hear what's being said in the courtroom without a microphone. So, what you sent me, the court clerks have received that.
Heeft u daar ook rekening mee gehouden om dat op papier bij u te hebben?
Ja, ik zal u toelichting geven.
Yes, I can give an explanation.
Niet de gelegenheid gehad om op papier.
I haven't actually had the opportunity to put down on paper what I want to explain, but that will come later, Your Honour. Please go ahead. Yes, thank you very much, Your Honour. Your Honours. More than 5 years ago, on 17 July 2014, Malaysia Airlines flight MH17 was shot down. All 298 people on board, men, women, young adults and children, lost their lives. The oldest victim, Gerda Liliana Lahenda, was from Indonesia and was 82 years old when she died. The youngest victim, Benjamin Lee Jian Han, was from Malaysia and was just 1 year old. On 17 July 2014, not only 298 lives were lost, many more lives were never the same after that day, and the loss of loved ones left deep wounds in the lives of the victims' families. Their loss was compounded by the delay they faced before they could say farewell, the uncertainty of whether a loved one's remains could be brought home, the shock they felt if it did happen, often on successive occasions, the grief they felt if it didn't happen. Two parents who lost their only child described their grief as follows. Death has become something different now. It's not something to be afraid of anymore. We're just serving out our days now, and after we die, maybe we'll be with her again. Another relative explained in detail how everyone in the family had responded differently and how difficult that had been. She described her sorrow like this. Everything feels meaningless. I've no energy anymore. I've lost all connection with life's goodness. We are only too aware that while this criminal trial will come as a relief to some of the next of kin, for others it will be a heavy burden to bear. Every time the MH17 investigation appears in the news, one relative feels hope, while another feels their wounds reopen. Wounds that even in the best circumstances will not heal quickly. The experience varies strongly from one person to another, and all these emotions, however different, are perfectly understandable. The victims in this case and the next of kin, of course, come from many countries all over the world. The Dutch Public Prosecution Service is doing its utmost to achieve justice for them all. We and our partners in the Joint Investigation Team, the JIT, will ensure that all the victims' relatives will be informed as well as possible about the trial and, where possible, about the investigation. To this end, we are working closely with government officials of all the countries that lost nationals in this tragedy, referred to as the grieving nations. Naturally, it is enormously helpful that the courts decided to live stream these so that anyone can watch them, wherever they are in the world. To ensure that these proceedings are conducted with due care, we will be speaking in our mother tongue, Dutch. But we are here to achieve justice for all the victims and all the next of kin, wherever they live or come from, and whatever language they speak. In addition to the next of kin, the residents of the disaster area in Ukraine are another group who will never forget 17 July 2014. Many of them were directly confronted with the horrific consequences of the downing of flight MH17. Wreckage and bodies fell from the sky, sometimes straight through the roofs of their houses. In eastern Ukraine, many ordinary residents and emergency personnel worked in difficult conditions in the midst of an armed conflict to recover the victims' bodies and later to commemorate the tragedy. Their efforts deserve the highest appreciation. Equally deserving of appreciation are the many investigators, experts and other parties all over the world who, over the past few years, have worked patiently and tirelessly on the investigation of this case. It is an exceptionally complex investigation, not least because of the armed conflict on the ground, the Russian Federation's active efforts to obstruct the investigation, and the risks faced by local witnesses who live in a lawless area where might is still right. It is to the enormous credit of everyone involved from many countries that despite those challenges, the JIT, has largely succeeded in establishing what happened on 17 July 2014. Not only the 5 countries of the JIT, Australia, Belgium, Malaysia, the Netherlands and the Ukraine, but also the many other countries that have contributed to the investigation in other ways, for example, by providing legal assistance. The JIT could never have taken this investigation as far as it has without the courage and commitment of countless journalists and ordinary citizens, citizens who've chosen to testify about what they saw, despite the risks to themselves. Journalists and citizens who, with great resolve, conducted their own investigations and then reported their findings. The JIT made grateful use of these findings too, as it steadily progressed with its own investigation, although it always had to analyse and verify the work of other parties. But having said that, the many and varied contributions of ordinary citizens to this investigation were so substantial that they too deserve great appreciation. The extent to which committed individuals were able to help establish the truth in this case inspires hope. We may live in a time where lies seem to be told often and easily, but thanks to today's many digital investigation tools, the determination and ability of ordinary citizens to expose those lies are greater than ever. This investigation is a reaffirmation that the truth will come out. All of these joint international efforts have resulted in the case file that will now be presented to the court. It deals with the investigation of all the possible causes of the downing of MH17. The JIT previously announced after long and careful investigation its findings concerning the primary scenario that flight MH17 was shot down by Buk-Taylor missile installation from the Russian Federation. The JIT also investigated several other scenarios that flight MH17 crashed following an onboard explosion, that it was shot down by a fighter aircraft, or that it was shot down by the Ukrainian armed forces. All these scenarios are examined in the case file, and all the relevant evidence is elucidated. That evidence includes many documents provided by the Russian Federation. All information that the Russian Federation has given the JIT or announced during press conferences was weighed up and analysed in the course of the investigation. We look forward to explaining the course and the findings of the investigation in more detail here at this hearing. After assessing all the evidence, the court will have to reach a judgment as to whether the defendants are guilty or not guilty. There are Igor Girkin, Sergei Dubinsky, Oleg Pulatov, and Leonid Karchenko. I'm now going to address the context of these criminal proceedings. Well, there have been other cases elsewhere in the world of civilian aircraft shot down. There have also been other cases of large-scale killing of civilians in military operations. These cases have seldom led to criminal proceedings against those responsible, and this may raise the question why this case warrants a criminal prosecution. As such, one must consider that the downing of flight MH17 differed in two respects from other tragedies where aircraft were shot down, even if, at first glance, they may seem similar. First, the investigation shows that flight MH17 was not shot down during a military exercise or by armed forces who believed that they were defending their country from a perceived attack. The Buk-Taylor that downed flight MH17 should have never been in Ukraine. It should have never fired a missile there, whether aimed at a civilian or military aircraft. This makes the assessment of this case fundamentally different from cases where errors of judgment during a legitimate military operation result in the loss of civilian life. Second, the parties responsible for downing flight MH17 have taken no responsibility whatsoever for their actions. In other, seemingly similar cases, sooner or later, at least some degree of responsibility was accepted. This is crucial. It's important to be able to establish what actually happened. It is important to the next of kin that clarity be obtained and responsibility accepted. It is also important to prevent, as far as possible, similar tragedies from occurring in the future. An effective investigation, openness about the findings of that investigation, and, where possible, punishment of those responsible, not merely a moral obligation to the families of the victims, but it's also a legal obligation under international human rights conventions. Both the entirely illegal character of the firing of the missile and the lack of accountability accepted afterwards by those responsible make the downing of flight MH17 different from seemingly similar tragedies. Both aspects make this criminal prosecution necessary in order to establish what actually happened and to punish an act of large-scale lethal violence that was not simply an error but should never have been planned or carried out in any form or against any target whatsoever at that place on the 17th of July 2014. These criminal proceedings are not the only legal proceedings concerning the downing of flight MH17.
worden ook interstatelijke procedures
Interstate proceedings are also being conducted. Ukraine has instituted proceedings against the Russian Federation before the International Court of Justice, partly in relation to flight MH17. The Netherlands and Australia have formally held the Russian Federation responsible for the downing of flight MH17.
Er lopen verschillende procedures
Various
tegen
proceedings against the Russian Federation and Ukraine have been instituted before the European Court of Human Rights in Strasbourg. The Dutch government has announced an inquiry into the facts surrounding the question of whether the airspace above and around eastern Ukraine should have been closed. In addition, the JIT's criminal investigation is still ongoing. The team has announced that it's still investigating other individuals involved in the downing of flight MH17. The JIT is focusing in particular on the members of the crew of the booktailer that was used and on responsible parties in the chain of command, including in the Russian Federation. All this requires that due care be taken in delineating the boundaries of the various procedures and the exchange of information between them. At the same time, it need not distract us from the questions confronting us in this criminal trial. This trial is about whether 4 defendants are guilty or not guilty of the offences with which they are charged. Nothing more and nothing less. It is not uncommon for there to be other simultaneous legal procedures underway concerning the same offences. Nor is it uncommon for the investigation of other potential persons of interest to still be ongoing. In the investigation of drug-related cases or other homicide investigations, for example, suspects are regularly charged with offences while the investigation of other persons of interest continues. What is required is that the role of the suspects to be prosecuted can be satisfactorily established, not that this can be achieved immediately and simultaneously in respect of every individual involved. A criminal trial is not a comprehensive attempt to establish the historical record. It is an investigation of the accusations against the defendants who are on trial. That is the case here too. It is also not uncommon for questions to remain, quite apart from the criminal proceedings, about the conduct of the authorities concerned, whether they should have done more to prevent the crime. Such questions are always investigated separately from those criminal proceedings. This is because the answer to the question of whether public authorities could have done more to prevent a murder can never absolve the murderer. A criminal trial deals with whether the defendant is guilty or not guilty. The question of whether Ukraine should or should not have closed its airspace is therefore outside the scope of these proceedings, just as there are many other questions that may be asked and could lead to useful answers, but not here and not in these proceedings. In this courtroom we're concerned with what Igor Girkin, Sergei Dubinsky, Oleg Pulatov and Leonid Karchenko did on and around 17 July 2014. Lastly, any decision by other countries to hold the Russian Federation responsible also does nothing to detract from the charges being brought in this courtroom against the 4 defendants. State responsibility is a separate matter from criminal responsibility of individuals. Criminal offences, are committed by individuals, and individuals must be held accountable for their crimes, even if they are acting as part of a larger whole, and states may therefore also be culpable.
As you can see, none of the 4 defendants has complied with the summons by the Public Prosecution Service to appear today in court.
De verwachting is dat dit op andere zittingsdagen
The
niet
situation is not
anders zal zijn.
expected to be otherwise on subsequent days either.
Een vraag die mogelijk bij veel mensen leeft,
Many people may
is waarom
wonder
het Openbaar Ministerie
why the Public
een proces
Prosecution
begint
Service should embark on a
waarbij bij
trial
voorbaat al viel te verwachten
when
dat
it
de
could be
verdachten
assumed in
niet zouden
advance
komen opdagen
that the defendants would not appear,
en waarbij het ook zeer de vraag is
and when
of
it's
de
highly
verdachten,
questionable
als zij
whether
worden
the
veroordeeld,
defendants, if
ooit
convicted,
daadwerkelijk een
will ever
straf
be punished
zullen ondergaan.
in practice.
Wij hebben ons deze vragen uiteraard
We've
ook
naturally
gesteld,
considered this
maar
question
hebben geen
as
moment
well,
getwijfeld aan
but
de
we never
noodzaak van deze
once
strafzaak.
doubted the necessity of this criminal trial.
Een strafzaak draait namelijk
A
ook
criminal
om het
trial, after
vaststellen
all,
van wat er precies
is also concerned
gebeurd.
with establishing what precisely happened. It's about
Een
establishing the
verdachte
truth.
kan daarbij een belangrijke
A
rol
defendant can
spelen
play a
door
key
een
role
verklaring
in
af
that
te leggen
process
over wat
by
er in
giving
zijn
evidence
ogen
about
is
what, in
voorgevallen.
his view,
Maar
occurred.
zijn inbreng is niet
But his
noodzakelijk
participation is not
voor een
necessary
legitieme uitkomst.
for a legitimate outcome.
Het komt in strafzaken
It
geregeld
is
voor
fairly common
dat
in
de
criminal
verdachte niet
trials
op de zitting
for a
verschijnt
defendant not to appear
of daar wel
in
komt,
court
maar weigert
or to
een
appear
verklaring af te
but to
leggen.
refuse to give evidence.
Ook in die zaken
In
zal de
such
rechter
cases
op
too,
basis van het
the
aanwezige
court must,
onderzoeksmateriaal
on the basis
een
of
oordeel
the
moeten
evidence
vellen
presented,
over
reach
de
a
vraag wat er
judgment
is
on
gebeurd
what happened
en wat de strafrechtelijk relevante rol
and
van
what
de
the role of
verdachte
the defendant
daarbij
was
is
in the
geweest.
context of criminal law.
Dat is in deze zaak niet anders.
This case is no different in that respect.
Wij menen dat het onderzoek van
In
de
our view,
afgelopen 5,5
over the
jaar
past 5.5
zoveel materiaal
years,
heeft
the investigation has
opgeleverd
produced
dat
so
uw
much
rechtbank
material
voldoende in staat
that your
zal zijn
court
om een
will be
gefundeerd
sufficiently
oordeel te
capable
vellen
of reaching a
over wat er is
well-founded
gebeurd,
judgment on what
ook
occurred,
zonder de inbreng
even
van de
without
verdachte.
any input from the defendants.
Daarbij doet het Openbaar Ministerie
The Public
er alles
Prosecution
aan
Service
wat
will do
redelijkerwijs
everything
mogelijk
that
is
is
om de
reasonably
verdachte
possible
de kans te
to
geven
give the
hun
defendants
kant
the
van het
opportunity
verhaal te
to tell
vertellen.
their side of the
Wij
story.
zullen daar zo dieper op ingaan.
We'll discuss this in more detail shortly.
De mogelijkheid dat de verdachte in
The
deze
possibility
zaak
that the
ook
defendants
na
in
een
this case
veroordeling geen straf
may not
zullen
face
ondergaan,
punishment,
zien wij niet
even
als
if
reden om
convicted,
af te zien
is not
van
in
dit
our view
proces.
a reason to forgo a trial.
Strafoplegging is vaak een belangrijk
Sentencing
onderdeel
is
van
often
het
a key
strafproces,
element of a criminal
niet
trial,
steeds belangrijker
but
dan
it is
waarheid.
not necessarily more important than establishing the truth.
Bovendien is het geen uitgemaakte zaak
It is not a
dat de
foregone
verdachte aan
conclusion,
een eventueel
moreover,
opgelegde straf
that the defendants will
zullen weten te
succeed
ontkomen.
in evading a possible future punishment.
Wetten en verdragen
There
bieden
are
de
laws
mogelijkheid
and
dat de
treaties
verdachte
that provide for the
Nederlandse
possibility
straf
of
in het
defendants
buitenland
serving a
ondergaat.
Dutch sentence abroad.
Daarbij,
Also,
vandaag nog ongrijpbaar
a
lijkt,
person who
kan
appears
morgen
untouchable
alsnog zijn
today
rechtbank in de ogen
may
kijken.
still face a court tomorrow.
Als het in deze zaken tot een strafoplegging
Should a
komt,
sentence be imposed
zullen
in
wij
present
alles aan
proceedings,
doen om daaraan
we will
uit te
do
groeien.
anything in our everything in our
Nederland
power to
of
ensure
daarbuiten.
that it is enforced, whether in the Netherlands or
Kortom,
elsewhere.
Wij menen dat dit
In
strafproces
short,
ook zonder
it is our
deze
opinion that this
verdachte
criminal trial
noodzakelijk
is necessary even in the absence of the defendants
Uitgangspunt moet
themselves.
daarbij volgens ons zijn
The guiding
dat de
principle in this
zaken tegen
regard,
deze
in our
vier
view,
verdachten
is that the cases against these four defendants should as far as possible be heard at the same time and in
Om die
parallel.
reden zijn ze ook allemaal
For this
op
reason,
dezelfde zitting
all
bij
four
uw
cases
rechtbank
were presented to the court at the same hearing.
Omdat het hier in meerderheid gaat om
Since this
de
mainly
rechten bij
concerns
het
trials in
bestaat
absentia,
de mogelijkheid
it is possible that a
of zijn
defendant
advocaat zich
or
later
his
als
counsel
meldt.
should decide to appear at a later date.
Moet zijn zaak dan
Under the
opnieuw
law,
worden behandeld.
In such an event, his case must be heard again so that the defendant can still present his defense.
In zulke gevallen moet wel worden
If that
afgezien
occurs,
van gelijktijdige
the cases of these defendants cannot reasonably be tried in a joint trial, as this would subject all the cases to the same delay. That would not be compatible with the right of the next of kin to a timely proceedings or the interest of the efficient administration of justice. We therefore take the view that the guiding principle should be for these cases to be heard together where possible and separately where necessary. It's also quite conceivable that the cases against these four defendants may proceed at different speeds, but that your court ultimately gives a judgment on all four cases at the same time. How did we reach the decision to prosecute these four particular individuals? We'll gladly explain. The JIT has conducted an extensive open-minded and extremely thorough investigation into the downing of flight MH17. In the course of that investigation, the team profoundly examined various different scenarios, not only the scenario that the MH17 was shot down by a Buk missile, but also the scenarios that the MH17 crashed after an onboard explosion, that it was shot down by a fighter aircraft, and that it was shot down by a missile system other than a Buk. Only after extensive investigation did the Joint Investigation Team conclude that flight MH17 was shot down by a Buk missile launched from an agricultural field near the town of Pervomaisky to the south of the town of Snitsny, that a Buk teller of the 53rd Anti-Aircraft Missile Brigade of the Russian Army had been used for this purpose, and that this Buk teller was transported from the Russian Federation on the night of the 16th to the 17th of July 2014 and transported back to the Russian Federation shortly after the downing of flight MH17. Many people were involved in this course of event. In the case of the armed group to which the defendants belonged, the so-called Donetsk People Republic, the DPR, several dozens of people played a role in transporting and guarding the Buk teller. Several of them could not be identified in the investigation or have since died. Our point of departure when considering which of the identified suspects should and should not be prosecuted in Dutch criminal proceedings is naturally always the question of whether there is sufficient evidence to launch a criminal prosecution with a reasonable prospect of securing a conviction. On that basis, a number of individuals who in recent years have been linked in the media to the downing of flight MH17 had to be discounted. The open-minded approach with which the investigation was conducted and the decisions on prosecution were taken is clearly illustrated if we take a look at who is not on trial here today. Firstly, the Ukrainian Vladimir Tsemak. He was considered a suspect in July 2014 he was working in Snitsy in the air defense section of defendants' armed group. He was considered a suspect, and his extradition was requested from the Russian Federation. The Public Prosecution Service has, however, not yet decided whether Tsemak will be prosecuted. The investigation into his role has not progressed far enough yet. The evidence position against him is not comparable to the position with respect to the 4 defendants that have been charged in this criminal trial. Secondly, we would mention Igor Besler. He's a comrade of the 4 defendants in this trial. Much has been reported in the media about an intercepted phone conversation that he had on the afternoon of 17 July 2014. In that conversation, he told the person on the other end of the line that a bird was coming his way. That was a very short time before the downing of flight MH17. Both this telephone call and Besler himself were extensively investigated. That investigation was unable to establish that this conversation had actively contributed to the downing of flight MH17. The investigation revealed, moreover, that the time between this conversation and the launch of the missile was so short that it was questionable whether the conversation could have contributed to the downing of the aircraft. We would like to elaborate on this at a later point in time to be determined by this court. We did not, and as the things currently stand in the investigation, still do not consider that there is a provable criminal case against Besler in relation to flight MH17. In September 2016, the Joint Investigation Team appealed for witnesses concerning the identity of two individuals who in July 2014 were using the call signs Orion and Delphin. These individuals were probably two higher-ranking Russian officers who played a role in the armed conflict in eastern Ukraine. At the time of this witness appeal, in 2016, the JIT suspected that these men had also played a role in the downing of flight MH17. In an intercepted phone conversation on 14 July 2014, for example, Orion said that they now have a book and are going to shoot down aircraft. However, subsequent investigation that took place after September 2016 revealed that in the days prior to 17 July 2014, various persons and groups fighting the Ukrainian armed forces were trying to attempt to acquire a book system. Most of these attempts appear to have been unsuccessful. Orion's conversation on 14 July probably concerned a booktailer that was brought across the border from the Russian Federation, but then caught fire and was rendered useless before it could be deployed. Other telephone conversations featured discussion of box systems that were expected, but in the end were never delivered. The JIT's investigation ultimately yielded concrete information about only one book system that was in the area in question, and could actually be deployed on 17 July 2014. That was the booktailer that was brought to the agricultural field near Pervomansky. Therefore, in regard to Orion's telephone conversation, which in September 2016 seemed so relevant, we have now concluded, on the basis of the latest findings of the investigation, that the conversation was unrelated to flight MH17 and instead concerned a different bugtailor which caught fire before it could be used. It appears that Delphin, in any event, was involved in the removal of the booktailer that downed MH17. But at this point in the investigation, there is no evidence that his role was comparable to that of the four defendants in this trial. It should be noted that although a suspect's role after an offence has been committed may be relevant to the assessment of the part played overall, a criminal prosecution, above all, requires evidence that a suspect played a relevant role before and during the commission of an offence. To date, there is no such evidence where Orion and Delphin are concerned, and therefore they're not being prosecuted in these proceedings. This illustrates once again that in this matter we continue to weigh up the evidence with an open mind and draw the appropriate conclusions, even if this requires us to adjust our points of view. We go where evidence leads us, and only there. With regard to the group of suspects against whom the investigation produced sufficient evidence, we subsequently examined the role played by each separate individual. Only those who played a leading role can be prosecuted in the Netherlands. Of course, there should be no impunity for individuals who played a smaller role, but they can be prosecuted in Ukraine. Many DPR fighters played a minor role, taking no individual initiative themselves. This is true, for example, of those involved in transporting the booktailer or guarding it before and after the downing of the flight. Their cases can better be heard in Ukraine.
is dat ook al
and in
gebeurd.
several instances this has already occurred.
Zij zijn in Oekraïne strafrechtelijk vervolgd.
These individuals have already been prosecuted in Ukraine, not specifically for their supporting role that they played in the downing of flight MH17, but more generally for their participation in the DPR as members of a terrorist organization.
Van de strijders van de DPR
Among the DPR fighters, we view Girkin, Dubinsky, Pulatov and Kharchenko as leading players in the downing of flight MH17. Girkin and Dubinsky were top military leaders of the DPR. Pulatov and Kharchenko were Dubinsky's direct subordinates. Together, these four men took delivery of the book-tailor from the Russian Federation and deployed it as part of their own military operation, with the aim of shooting down an aircraft. The crew of the book-tailor pressed the button, but according to the indictment, it was Girkin, Dubinsky, Pulatov and Kharchenko who directed the employment of this weapon in order to serve their own interests. They discussed that they needed a buck in the intercepted conversations to launch it. They directed the book-tailor to the launch location. They had conversations afterwards as to whether the book had done its job, and they noted with delight that an aircraft had been shot down, and they directed others to remove the book-tailor and to take it to the Russian Federation. When it comes to evidence and responsibility, as of now, no other suspects in the investigation are in the same position as Girkin, Dubinsky, Pulatov and Kharchenko. As mentioned previously, the JIT's investigation is still ongoing. In complex investigations into offences involving many individuals, the Public Prosecution Service often has to take into account different factors and interests when deciding whether or not to prosecute. Not only the interest of being able to thoroughly investigate all parties of interest without hindrance, but also that of the next of kin in obtaining clarity as to what happened as soon as possible. Last year, this weighing up of interest led to the decision to summon these four defendants. The continuing investigation is particularly focused on the crew members of the book-tailor that was used and on the chain of command, even in the Russian Federation. It remains to be seen whether this part of the investigation will result in a criminal prosecution against other individuals in the future. The Prosecution Service does not expect to be able to take more prosecution decisions in the near future. This phase of the investigation, if anything, is more complex than the first phase. Whatever the outcome of the continuing investigation may be, it does not detract from the importance and the necessity of holding these defendants to account now for their role in the downing of flight MH17.
Now I will be discussing the decisions in drafting the indictment. The four defendants are charged with intentionally causing the aircraft to crash, resulting in the deaths of 298 people on board and with the murder of those 298 victims. In our view, these charges clearly expressed what in fact occurred. We do not think that these defendants pressed the button that launched the Buck missile. However, we do think that they played a significant coordinating role in the transportation and positioning of the book-tailor and in its removal back to Russia, making them so closely involved that they can be held responsible under criminal law for the downing of flight MH17. It is perfectly conceivable that the true intention of these four defendants was to shoot down an aircraft of the Ukrainian armed forces. Several items of evidence point to this scenario, including intercepted conversations that the defendants had after the downing occurred. It is, of course, up to the court, having fully considered the case file in this courtroom, to reach a judgment on this evidence. In drafting the indictment, we explicitly took this error scenario into consideration. The offenses with which the defendants are charged concern the prohibition on causing any aircraft to crash and on killing another person, regardless of the type of aircraft and regardless of the military or civilian status of that other person. In the Netherlands, anyone who destroys a Royal Air Force fighter aircraft can also be prosecuted under 168 of the Dutch Criminal Code and for the murder of the pilot. The offenses on the indictment are equally applicable to the downing of a military aircraft as to the downing of a civilian aircraft. In principle, any error concerning the target makes no difference in respect of the proof that such offenses were committed. That is why in the Netherlands and in many other countries, people are convicted of murder if they happen to shoot dead a passerby rather than their intended victim. And the fact that in July 2014 an armed conflict was taking place in Ukraine received consideration drafting the indictment. As you know, in July 2014, eastern Ukraine was the scene of heavy fighting between the Ukrainian armed forces and various armed groups. It is true that the rules that apply in wartime and peacetime may differ. This is the doctrine of combatant immunity, according to which military personnel may participate in hostilities within the limits of international law. These different rules, however, apply only to regular military personnel operating under the authority of a state in a group that respects international humanitarian law and rules of warfare. Other people who commit acts of violence in an armed conflict are subject to the ordinary rules laid down in criminal law. War is not a license for violence by all against everybody. That's not the case in the Netherlands, nor is it the case in Australia, Belgium, Malaysia, Ukraine, or the Russian Federation. All states in the world in recent centuries have devised rules of warfare to limit the consequence of war violence as much as possible. The guiding principle is that wars are fought between military combatants and that civilians are not involved in any way. If civilians in Ukraine use violence against Dutch, Malaysian, Australian, and Belgian citizens, this violence, therefore, lies within the scope of the ordinary criminal laws of these countries. These civilians commit ordinary crimes such as murder and the downing of an aircraft leading to the deaths of its occupants. Regardless of whether they used a rifle or an advanced rocket launcher, and regardless of whether the intended victims were civilians or combatants. The same holds true for armed fighters in Ukraine who claim to be ordinary civilians. Ordinary criminal law applies to them as well. A license or immunity for deadly violence is granted only in very exceptional situations. This does not happen in situations of chaos and lawlessness, but exclusively when using controlled and proportionate force. Controlled means regular soldiers who are recognizable as such, who fight under the responsibility of a state in an organizational form which respects international humanitarian law. So not groups fighting independently or who fail to respect laws of armed conflict. Like any other civilians, members of such armed groups are not allowed to use force. Like anybody else, they are subject to ordinary criminal law. The same applies to soldiers who pretend to be ordinary civilians. This is also not allowed because it instigates reciprocal violence against real civilians. For this reason, soldiers concealing their true identity may be punished for resorting to such violence. To date, the defendants in this case have never asserted that in July 2014 they were regular military personnel operating on behalf of a state in Ukraine. Moreover, our investigation into the structure of their organization has revealed that in the summer of 2014 the defendants' armed group did not comply with the requirements of international humanitarian law. This part of the investigation, for example, has yielded a wealth of information about systematic and large-scale violations of international humanitarian law by the DPR in 2014 and thereafter. It concerns thousands of cases of looting, abduction of civilians, torture, inhumane treatment, executions of civilians and prisoners of war, laying prohibited landmines, and many other violations of international humanitarian law and the laws of armed conflict. Our provisional conclusion is therefore that the suspects in July 2014 were not entitled to claim combatant immunity and that they had no right or excuse to resort to violence in eastern Ukraine. Whoever systematically violates humanitarian law cannot invoke it to their benefit in a criminal trial. The suspects can therefore be tried for crimes such as murder and intentionally downing an aircraft. Now I will discuss the Public Prosecution Service's position in these proceedings. In Dutch criminal proceedings, establishing the truth is the central aim. Like the court, the task of the public prosecutor is to establish as accurately as possible what happened, whatever conclusions may result from that search for the truth. In the process, the Public Prosecution Service, like the court, must safeguard the legitimate interests of everyone involved: suspects, defendants, next of kin, and witnesses. At the start of this introductory address, I said that in this courtroom we want to achieve as fully as possible justice for all the victims and all the families, wherever in the world they are from. For that reason, Ukraine agreed, at the request of the Netherlands, to transfer the prosecution of the 4 defendants to the Netherlands. This was not, in fact, necessary for this trial to take place. The Netherlands, after all, has legal jurisdiction over the downing of flight MH17 by virtue of the Dutch nationality of a great many of the victims. That jurisdiction extends to the entire offense, i.e. intentionally causing an aircraft to crash, resulting in the deaths of everyone on board that aircraft, and with that, the murder of all occupants. To avert any doubt about the position of the non-Dutch victims, Ukraine was nevertheless requested to transfer jurisdiction. This highlights once again that all the victims in these criminal proceedings and all their next of kin have an equal place. In the run-up to these proceedings, many public prosecutors and victim coordinators have spoken with many next of kin who wish to speak with them. These were often extremely sad conversations. Relatives have told us in detail about their deceased loved ones, about their sense of loss, about the far-reaching consequences of the sudden loss of family members, about the grief that simply does not go away. We have also heard stories of people who have managed to go on with their lives while always keeping their loved ones close in their thoughts. We have heard relatives say that this trial can offer some hope, but that it will also be another difficult and emotional period in which their grief, pain, and loss will be omnipresent. We know that there are relatives who want to hear every word of this trial so that they do not miss any of it. But we also know that other relatives will deliberately avoid the news throughout this period so as not to be confronted again day after day with reports about MH17 and the emotions that will inevitably resurface. These criminal proceedings are expected to take a long time because thorough proceedings that take into account everyone concerned in a just, careful, and even-handed manner take time. It is important that the defense receive the time and opportunity to study and supplement the case file with anything the defendants wish to bring forward. If additional research by experts is needed, it needs to be conducted with due care. That takes time. The next of kin can expect the Public Prosecution Service to do its utmost to ensure that the trial does not run any longer than necessary and that we keep them as well informed as possible about the progress of the proceedings. In addition, we consider it important for the next of kin to give them insight into the structure of the criminal proceedings and the day-to-day progress. That means, for example, announcing as far as possible in advance what will happen on a given day and ensuring that unexpected matters of procedure are discussed in ad hoc sessions dedicated to that purpose. Only then can the next of kin and other interested parties decide properly how they wish to follow or, in fact, avoid the trial. In any case, this trial will take time, but as with the investigation from recent years, it needs to be done with care, and that, after all, takes time. As I have said, in Dutch criminal proceedings, the Public Prosecution Service must safeguard the statutory interests of the defendants, and this case is no different. To that end, we have made every effort to notify the defendants about this trial in time so that they may defend themselves if they choose. Irrespective of any response they may give in this courtroom, we have done our very best to include in the case file all relevant remarks made by the defendants about the charges, for example, in interviews concerning the charges against them. This will enable the court to obtain as clear a picture as possible of the defendant's standpoints, even if they themselves choose not to present a defense here in court. We have also investigated at great length the matter of whether the defendants could possibly claim combatant immunity, despite none of the defendants to date indicating that they consider themselves combatants. We will provide a more detailed explanation of that investigation at a moment to be decided by the court. Another of the Public Prosecution Service's tasks with regard to the defendants in the area of legal protection is to ensure that all the evidence is considered critically. During the investigation in recent years, very extensive studies were conducted of the authenticity and reliability of the evidence that had emerged in the course of the investigation. That's known as a validation study. Not only have extensive analyses been performed of the internal cohesion between items of evidence, but many different experts have been consulted too. This has resulted in multiple kinds of validation studies, such as expert forensic investigation, meteorological studies, empirical comparative studies, and expert studies concerning missile technology. We took seriously associations that intercepted phone conversations and open source visual materials had been manipulated and submitted them to independent experts. It is thus not a matter of depending solely on the defendants or the defense for critical assessment of the available evidence. We would like to elaborate on the way in which this important validation research was done when the court finds that it is appropriate with the scheduling of the trial. Nonetheless, the defendants themselves are the people best able to present their points of view. That is why the Public Prosecution Service has done everything possible to give the defendants that opportunity. And indeed, they have every opportunity. They can appear here in person. They can send a lawyer to explain their side of the story. They can testify to the Russian authorities. They may respond via the website or via social media. They may send a video message or respond to written questions. There are countless ways in which the defendants in this case can present their points of view. Issues of distance or national borders need not be an obstacle, as demonstrated by the fact that several former separatists, including somebody such as Igor Bessler, have already given statements to the JIP. Anyone who does not do this remains silent by choice. Many dozens of witnesses wanted to share what they experienced on 17 July 2014 and in the period before and after that day. How they saw the Buck Taylor being transported, what they saw at the missile launch site, what they knew about the defendants' organizations. All these accounts provided crucial information for the investigation. They are pieces of a puzzle which, together with the forensic evidence, the photos and videos, the telephone intercepts, expert reports, and all the other evidence, form a robust case file. Witnesses in the DPR-controlled area in eastern Ukraine and witnesses from the Russian Federation run a serious risk when giving statements the authorities there consider to be treasonous. For that reason, the examining magistrate has decided that the identities of dozens of witnesses in this case file must remain secret. This is unfortunately a necessary requirement to enable those witnesses to tell their account safely. When we explain the investigation in full, we will discuss in more detail the need to use anonymous witnesses in these proceedings and the strict guarantees that apply in this regard. Since 17 July 2014, the investigation into the circumstances of the downing of flight MH17 has been complicated by many attempts to distract attention from the actual course of events, not only through deliberate spreading of lies and disinformation, but in some cases due to people who in this tragedy saw an opportunity to make money or attract attention to themselves. Over the past few years, the investigation team has done its utmost to focus its time and energy as much as possible on helping establish the truth and not allowing itself to be caught up in the many attempts to distract, mislead, and actively obstruct the investigation that we have seen in this case to date. During these criminal proceedings, this will be one of the greatest challenges we face. In the period ahead, too, we must expect that considerable efforts will be made to distract attention from the facts and to obstruct the search for the truth in this case. It is therefore important to distinguish properly between the smokescreen that will no doubt be raised and the actual questions at the heart of this criminal trial. After more than 5 years of preliminary judicial investigation, it is now up to your court to lead the examination at trial and reach a judgment on the charges set forth in the indictment. This is a huge responsibility for several reasons. For many of the victims' relatives, obtaining clarity about the circumstances of the downing of flight MH17 is key to the grieving process. The importance of dignified and efficient criminal proceedings for the grieving of those who have lost loved ones is widely recognized in academic research and international case law, and there is a broader interest. The Russian writer Alexander Solzhenitsyn said that violence has no way to conceal itself except by lies, and lies have no way to maintain themselves except through violence. When hundreds of innocent people are killed, a world that doesn't take the trouble to establish the truth and punish the guilty sends the message that its people are fair game. Establishing the truth in this case may help prevent fresh violence in the future. That is another reason why it is so important to distinguish truth from lies here and to punish the guilty. That is the task with which we in this courtroom are tasked. Thank you very much, Mr. Prosecutor.
Presiding Judge says, thank you, that was your opening statement. And as I said earlier, we now come to the defense of Mr. Pulatov, and I now give the defense the opportunity to make that statement.
En u heeft uw bijdrage ook op schrift om uit te delen, zie ik.
I see that you have your submission in writing. Do the interpreters have that version? Yes, says counsel.
Dank u wel.
Meneer de voorzitter, leden van de rechtbank,
Your Honours,
van justitie, overige aanwezigen.
ladies and gentlemen, public prosecution, just as so many others, we also felt the enormous shock that followed after the news dawned on the world after July 17, 2014, 5 o'clock, a shock that had so many unimaginable terrible consequences for so many people and caused unsurmountable pain and indelible marks. Today, more than 5.5 years afterwards, the trial is starting against 4 persons that are being suspected of involvement in causing this disaster. We completely support the fact that today we reflect on the immense grief and pain of the bereaved. Throughout these proceedings, the public prosecutors, the next of kin of the victims and their legal counsel will undoubtedly and understandably try to do as much justice as possible and pay as much attention as possible to the consequences of the disaster. This heavy duty, not to be underestimated, is not ours. We are attending this hearing on behalf of one of the suspects, Oleg Pulatov, to exercise his right to defense. For some, the right to defense is self-evident. For others, it is not self-evident, or not in all cases. For them, the self-evidence that the rights of a defendant should be guaranteed may fade if the consequences of an offense are more serious. In a case as this one, in which the consequences are so terrible, the right to defense is questioned. The right to defense is a prerequisite for a trial to even have a chance to be fair. It's precisely the rights of the defendant that allow a trial to be fair. If a defendant has no rights, or if those rights are not being observed, a trial has no value whatsoever. It means, in a rule of law, i.e. the Netherlands, it means nothing, or the outcome thereof need have nothing to do with justice. And the wish to establish the truth is, besides a legal necessity, is human and understandable. The defense will not disagree on that. The importance of an investigation into the truth regarding the disaster of the MH17 is emphatically endorsed by us. But the danger that prevails here is not the search into the truth, but the danger is to be found in the wish to point at a guilty party and to punish this person. And this, also human and understandable wish, can become part of a search for the truth. But if the wish to designate someone and point at a guilty party and punish that guilty party, if that becomes stronger, it can also be to the detriment of the establishment of truth. The rights of a defendant that envisage to guarantee that not the wrong person be unjustly found is therefore of essential importance. And for a trial to be fair, it's crucial that the rights of the defendant be fully exercised, and this is one of the duties of the defense to see to this. On June 18, 2019, it was announced that 4 names of the defendants would be disclosed by the JIT. One day later, the name of Oleg Pulatov, including his photograph, was world famous. Oleg Pulatov now also knows, just as the rest of the world, that he, along with an international warrant, is being suspected of criminally reproachable participation and involvement in causing the crash of the MH17 and or causing the death of all 298 passengers. The question expressed by many is why our client wishes to defend himself. Asking this question, why would someone want to defend himself against a charge of intentionally taking the lives of 298 people, could be considered as the answer to the question. Oleg Pulatov's position is that he is not responsible, not in any way, not with any participation, not in any capacity. He is not responsible for downing the MH17 and all the consequences thereof. He has stated in simple terms that he has nothing to do with causing the MH17 to crash. and therefore he wishes to defend himself against the charges in the court proceedings. The public prosecution has taken ample time to investigate and to reflect the findings of the investigation in the charges that we have in front of us. What's more, the investigation is still ongoing. It's quite understandable because this investigation can be referred to as being complex and complicated in very many respects. It is up to the defense to also conduct an investigation. This investigation will be focusing on a thorough analysis and assessment of the findings of the JIT and also the way in which the investigation was carried out and what was not investigated. And also the investigation of the defense will require the necessary time. And this time is needed in order to find out what the arguments are that the defense can present regarding the question as to whether the findings of the joint investigation team can or may justify the charges as presented. This is not a tactic to delay. It's a result of a right that has been laid down in treaties and conventions, a right to sufficient time and opportunity to prepare defense. We will, my associate Boudewijn van Dijk will be explaining which questions the defense in this connection can formulate or must formulate. And now I would like to speak on behalf of the entire defense and say that in exercising our duty, we cannot and may not close our eyes for the fact that this horrific disaster has taken place. We will not deny the terrible consequences of the disaster in any way. Quite the contrary, we acknowledge those consequences without any reservation. We were also shocked by the crash of the MH17, the arrival of the victims, the images of the coffins at the Eindhoven airport is something we will never forget either. As I said earlier on, it's not our duty to speak on behalf of the next of kin or for the victims. It is our duty to speak on behalf of Oleg Pulatov. And that is what we will be doing fully and completely. On his behalf, we will try to leave no stone unturned and to safeguard his right to defense. And there's always a certain tension between the interests of the defense and possibly at odds even with the feelings of those people affected by the disaster. This is sometimes unavoidable. Exercising the rights of the authorities and the possibilities of defense and the ensuing factual and legal interpretations can be harsh. We will do our utmost to, at all times, pay attention to respectfully dealing with the feelings of grief and pain that are so inextricably connected to this case. Thank you very much.
Dank u.
Ja, voorzitter. Leden van de rechtbank, geachte officieren van justitie en geachte toehoorders.
Public criminal lawyer in a case such as this one, and how a vast file such as this one needs to be properly balanced prior to adjudicating it.
Ik benadruk daar ook graag bij, voorzitter, onze
file is modest. We just obtained that recently, and it's voluminous. So we do not have a comprehensive impression of the material in the record. Nonetheless, it is already clear that despite tens of thousands of pages, many topics will require additional investigation. To illustrate that many questions remain unanswered, I will discuss one example, which just happens to be a topic raised in the introduction by the Public Prosecution Service. The aviation terms and abbreviations that I will use will be known to the parties to the proceedings. This may not be the case for other listeners, which is why I will be explaining the terms and abbreviations I use.
Het onderwerp dat ik wil bespreken heb ik betiteld als
I have
het luchtruim boven
titled the topic I'd like to cover as the airspace above eastern Ukraine in June and July.
In de Tweede Kamer hier in
2014.
Nederland zijn in 2018
In the House of
vragen gesteld aan de
Representatives
minister van Justitie
in the
over
Netherlands in
het onderzoeken
2018,
van de
the Minister of Justice was asked questions about
voor het niet volledig
investigating
sluiten van het
the
luchtruim.
liability of Ukraine as a state for not completely
Door de
closing
minister is
the
onder meer
airspace.
geantwoord
The
dat het niet
minister's
sluiten van het
reply
Oekraïense
was in
luchtruim
part that
nooit
failing to
onderwerp
close
van
the
het
Ukrainian
strafrechtelijk onderzoek door
airspace
JIT is geweest.
had never been subject to a criminal investigation by the
Mede op
JIT.
grond daarvan is op antwoord van
Based
andere
in part
Kamervragen
on that,
ook aangegeven
in response
dat
to
naar het
other
oordeel van het
questions
kabinet op dit
from the
moment
House of
geen juridisch
Representatives,
overtuigend bewijs
it was
is voor
indicated that, in
succesvolle
the view of
aansprakelijkstelling
the
van
Council of Ministers,
Oekraïne.
at this time there is no legally convincing evidence
Tevens werd in 2018 in de
of
Kamer de vraag
successful
gesteld of Oekraïense
holding Ukraine
luchtverkeersleiders
liability.
door
It was
enige
also
instantie zijn
stated in
gehoord
2018
in
in the
het
House of
kader van
Representatives
MH17
that the
en
question
of
had
die
been asked
verhoren
whether the
enige rol
Ukrainian
hebben gespeeld bij het huidige tussenoordeel van de regering
air
dat
traffic
Oekraïne
controllers
thans nog niet
or any other
staatsaansprakelijk kan worden
institution,
gesteld.
they had never been examined in the context of the MH17, or
Daarop is
whether those
geantwoord,
examinations had
strafrechtelijk
figured in the
onderzoek van het
present
JIT is nog
interim
gaande. Dit
judgment
was in
of the government
2018.
that Ukraine
De vraag
can
of in
still
dat
not
kader
be held
verkeersleiders
liable.
of
The
welke personen
reply
dan ook
was
zijn
the criminal
gehoord, kan ik dan
investigation
nog
of the
niet
JIT
beantwoorden.
is ongoing, so the question as to whether air traffic
In het
controllers or
onlangs aan de
others
verdediging
were
ter
examined
beschikking
cannot be
gestelde
answered now. The
strafdossier is onder meer te
prosecution
lezen
file recently
dat in
made
de
available
3
to
en
the
2 jaar
defense
daarvoor, dus voor de beantwoording
reveals
van
that
die
in the
Kamervragen,
2 to
in
3 years before that, so
2015 en
before
16,
those questions were
12
answered in the House of
luchtverkeersleiders
Representatives
zijn
in
gehoord door
2015
JIT.
and 2016,
Veelal door
12 air
Nederlandse
traffic controllers were examined by the
in
JIT,
aanwezigheid van de
generally
geheime dienst van Oekraïne.
by government officials in the presence of
Tijdens
the
deze
Ukrainian
12
Secret Service.
verhoren
During these 12
is aan geen van de
examinations,
luchtverkeersleiders
none of the air
gevraagd
traffic controllers
wat de
was asked
precieze redenen
what the
zijn
exact
geweest
reasons
voor het
had
sluiten
been
van een gedeelte
for
van het
closing
luchtruim boven
part
Oost-Oekraïne.
of the airspace above eastern Ukraine,
En waarom daarbij
or
een hoogte
why in the
was
process
ingesteld van
the altitude
32.000
set
voet.
was
In het
32,000
dossier
feet,
aangeduid als
indicated
FL320
in the
en
record
FL staat dan
as
voor flight level.
FL320, FL denoting flight level.
Evenmin is, voor zover de verdediging nu kan zien,
Nor
onderzocht
was
door
examined,
welke
as far as the
personen
defense
deze
can
beslissing
tell at
is
this time,
genomen
which
en wat de
persons
precieze
took this
redenen
decision
daarvoor
or
waren.
what the exact reasons were for taking the decision.
Ik zal uitleggen, voorzitter,
I
waarom
will
het
explain,
naar ons
Mr.
inzicht
President,
opmerkelijk
why
is
in
dat
our view
dergelijke
it's
vragen
remarkable
niet zijn
that such
gesteld,
questions were
althans
not
dergelijk
asked,
onderzoek niet uit het dossier
or at any
blijkt, uit
rate,
het strafdossier.
no such investigation is clear from the prosecution file. One of the annexes to the prosecution file is the investigative report by
En dat is een belangrijke bron voor
the
wat
Dutch
ik
Safety
nu
Board.
ga vertellen.
And that's an important source for
Uit
what
dat
I'm about to
rapport
tell you.
is op te maken dat de
Based on that
MH17
report, it may be
kort voor
inferred
het
that
ongeluk
shortly before the
vloog
accident,
op de
the
minimale toegestane
MH17
hoogte
was
van
flying at
33.000
the
voet
minimum
en
permitted
dat
altitude
MH17 vlak
of
voor het ongeluk door de
33,000
luchtverkeersleiding was verzocht
and that
om naar
just
een
before the
hoogte te
accident,
stijgen van
the air traffic
35.000 voet
controllers had
in verband met een
requested the
ander naderend
MH17 to
burgerluchtvliegtuig.
rise to a level of 35,000 feet in connection with
MH17 kon niet
another
aan dat
approaching
verzoek
civilian
voldoen
aircraft. The
en bleef op
MH17
een
was
hoogte van
unable
33.000
to
voet
comply with that
vliegen.
request
Dat is
and
circa
continued
10
flying at
kilometer.
33,000 feet, which is about 10
Een van
kilometers in
de
altitude.
door het JIT verhoorde luchtverkeersleiders
One of the air traffic
verklaart uit
controllers
zichzelf,
examined
niet
by the JIT
specifiek
stated
op een vraag,
independently, not
dat het
necessarily in response to your question,
luchtverkeerscentrum in
that the air traffic control system in
Dnipropetrovsk, ik hoop dat ik het goed uitspreek,
Dnipropetrovsk
de betreffende luchtruimtebeperking heeft
had
ontvangen
received
van, en ik
the
vertaal dat
corresponding
maar even, de luchtverkeersdiensten
airspace
in Oekraïne.
restriction from the air traffic
Kiev.
controlling services in Ukraine, in Kiev.
Voor zover voor de verdediging thans zichtbaar in het
To
strafdossier
the extent
zijn naar aanleiding van
made
deze
visible by
opmerking
the
van deze
made
getuigen
visible to the
geen
defense in this
personen gehoord van de
prosecution
betreffende
file
instantie in
based
Kiev.
on this remark,
En is
no,
deze lijn dus
but
niet
it was
verder
examined
uitgerechercheerd.
at that organization Kiev. So
Naar
this
alle
line
waarschijnlijkheid
of investigation
klopt
has
het
not been
dus wat de
pursued.
minister
So
van
in all
Justitie
likelihood,
in september
what the Minister of
2018 antwoordde op
Justice
vragen van de
replied
Kamer,
in September
namelijk dat het
2018
niet sluiten
to
van het Oekraïense luchtruim
questions
nooit
from
onderwerp
the
is geweest van het
House is
strafrechtelijk
probably
onderzoek.
true, namely that closing the Ukrainian airspace
En
was
de
never
vraag,
the
voorzitter, is
subject
natuurlijk,
of
is
the
dat de
criminal
juiste
investigation
keuze van het
conducted
JIT
by the
geweest?
JIT.
En
And the
het OM heeft
question
daar
is
net al
whether
wat
that was
over
the right
gezegd.
decision on the
En
part
daar
of the JIT.
verschillen
And
we
the
van mening over.
prosecution service
Want mijn
has
antwoord op die
spoken
vraag
about
is
that. And
nee, dit is
we
geen
differ
juiste
on
keuze
that
geweest.
because my answer is no, that was not the
En ik
correct
zal dat toelichten
decision.
aan de hand van andere
And I'll
bronnen
explain this
dan
based
door
on
het JIT
other sources
geproduceerd, zoals met
than
name
the
dat
ones
rapport van de
produced
onderzoeksraad
by the
en ook nog
JIT,
wat
i.e.
kamerstukken.
the report from the
Daar word ik toe
Dutch
genoodzaakt omdat de onderzoeksresultaten van het
Investigative
JIT in het
Board
strafdossier
and the
er
House
dus
of
weinig tot
Representatives.
niets over zeggen.
This is because the
De
documents in the
onderzoeksraad geeft in
prosecution
het rapport
file
aan dat
reveal little or
elke
nothing
staat
about that.
de
The investigative board
soevereiniteit heeft
indicates
over
that
het
each
luchtruim
state
boven zijn eigen
has
grondgebied.
sovereignty over the airspace above its own territory.
Dat betekent volgens de onderzoeksraad
This means, according
dat de
to the
zeggenschap
investigative
over het
board,
eigen luchtruim volledig en uitsluitend
authority
ligt
over
bij
the
de betreffende
airspace
staat.
lies exclusively with that state.
Door middel van overeenkomsten die staten onderling sluiten,
Agreements that
stellen
states
zij hun luchtruim
reach
open
with each
voor
other,
luchtvaartmaatschappijen
they
van andere
open
staten.
their airspace
Een
to
staat
airlines
kan
of
vanuit
other
het oogpunt
states.
van veiligheid bepaalde
Based on safety
beperkingen stellen
concerns, a state
aan het
may
gebruik
set certain
van zijn
restrictions
luchtruim en bepalen langs
regarding
welke
the use of
routes
its
en op welke
airspace and may
minimale hoogte
determine
luchtvaartuigen
along which
mogen
routes
vliegen
and at
binnen
what
dat
minimum
luchtruim.
altitude aircraft can fly within that
De
airspace.
beherende staat kan het luchtruim ook
managing
geheel
state
of gedeeltelijk
May
sluiten
also
als
close
dat
that
vanwege
airspace
veiligheid
entirely in
noodzakelijk
part
is.
if necessitated
En dergelijke
for safety
beperkingen van
considerations,
het
and such
luchtruim
restrictions of
worden
the airspace
uitgevaardigd door een
are issued
zogenaamde
by what is
notice to airmen,
known
door
as a
mij verder
notice to
afgekort
airmen,
als een NOTAM.
hereafter abbreviated as a NOTAM.
En de onderzoeksraad geeft ook aan
And the
hoe het
investigative
met die
board
NOTAMs
has also
precies stond in juni en
described the
juli
status of
2014.
NOTAMs in June and July 2014.
Op 5 juni 2014
On 5 June
publiceerden
2014,
de Oekraïense
the
autoriteiten
Ukrainian
een
authorities
NOTAM
published a
waarmee het
NOTAM
gebruik van het luchtruim in het
that
oostelijk deel van
restricted the
Oekraïne
use of airspace
door de
in the eastern
burgerluchtvaart
section of
beneden
Ukraine
FL, dus
for
flight level
civilian
260,
airspace
tijdelijk beperkt.
above FL
Deze
flight
NOTAM
level
was geldig
260
van
temporarily.
6
This
tot en met 30 juni
NOTAM
2014.
was in effect from 6 through 30 June
Op 26
2014.
juni
On 26
2014
June 2014,
publiceerden
the
de
Ukrainian
Oekraïense
authorities
autoriteiten een andere
published
NOTAM,
another NOTAM
waarmee de tijdelijke
with
beperking
which
voor
the
het betreffende
temporary
gebied werd
restriction
verlengd.
was extended for
En die
that area
NOTAMs waren
concerned.
geldig van
Those
1
NOTAMs
tot en met 28 juli
were in effect from
2014.
1 through 28 July 2014.
Op 14 juli
On 14 July
2014,
2014,
3 dagen voor de
3
ramp,
days before
verhoogden de
the
Oekraïense
crash, the
autoriteiten
Ukrainian
de
authorities
beperking van het luchtruim tot
increased the
flight
restriction
level
of the
320.
airspace to flight level 320.
En de NOTAMs daarvoor die waren
The
geldig van
NOTAMs
14 juli tot en met
for
14
that
augustus 2014.
Were in effect from 14 July through 14 August
De OVV
2014.
vermeldt daarbij dat de
The Dutch
redenen
Safety
voor de
Board
beperking van het
indicates
luchtruim en
that
die
the
verhoging
reasons
niet
for
in de
restricting the
betreffende NOTAMs zijn
airspace
vermeld.
and the increase in that are not
Van
indicated
belang is ook
in the relevant
dat
NOTAMs. What's
de
also
onderzoeksraad
important is that
de autoriteiten
the Dutch Safety
aan de
Board
Russische Federatie, de autoriteit van de Russische Federatie heeft gevraagd welke
asked
NOTAMs zij
the
hadden
Russian
uitgevaardigd.
Federation which
En
NOTAMs
daar
it
is
had issued.
informatie over gekomen. Op
And
16
information was
juli
received on 16
2014
July
zijn
2014.
er door de Russische
The
autoriteiten
Russian
twee NOTAMs
authorities
voor het zogenaamde
issued 2 NOTAMs for
Rostov-gebied
what was known as the
uitgevaardigd.
Rostov
Een
area,
gebied dat grenst aan de
the
regio
area adjacent to
Dnipropetrovsk
the
in het
Dnipropetrovsk
oostelijk deel
region
van
in
Oekraïne.
eastern Ukraine.
De ingangsdatum van deze
The
NOTAMs
effectiveness date for these NOTAMs, so
17
the
juli
date they started to
2014 om
be
00:00
effective,
uur.
was 17 July at 0000 hours. Both NOTAMs referred to the armed conflict in eastern Ukraine as a reason for issuing those NOTAMs. The NOTAMs concerned effectively set the same altitude restrictions as the Ukrainian NOTAMs, FL 320, that is. At the bottom of one of the Russian NOTAMs, it says that it applies to the section of the airspace from flight level 530, which was a much higher altitude, i.e. 53,000 feet or 16.1 kilometers in altitude. That flying altitude is about 6 kilometers higher than the altitude that the MH17 reached. The Russian NOTAMs were admittedly focused on the Russian airspace, not on flying over eastern Ukraine, but did refer specifically to military operations in eastern Ukraine and the risks they entailed for civilian aviation as a reason for these restrictions of the airspace. Regarding questions from the Dutch Safety Board, which did ask questions about that, the authorities of the Russian Federation replied that restrictive measures were taken to align with the restrictions in the adjacent Ukrainian airspace. The Dutch Safety Board, however, did not obtain a clear explanation about the significance of the restriction to flight level 530 because flight MH17 was also going to fly over the Rostov FIR. These Russian NOTAMs, according to the Dutch Safety Board, figured in the briefing package for flight MH17. Despite the differences in altitudes mentioned in the Russian NOTAMs, these, according to the Dutch Safety Board, have both been accepted by the automated flight plan system. Exactly what this means, Mr. President, has not become clear to me after reading the report by the Dutch Safety Board. According to the Dutch Safety Board, the flight plan did not envisage rising to flight level 530. The questions that may surface there, for example, and they're selected, are as follows. In what manner was the flight level 530 for Russian territory included in the flight plan? Why didn't the flight plan provide for an ascent to flight level 530? Would the MH17 have had the same flight route as provided for in the MH17 flight plan? And could the flight plan have accommodated this if the ascent from flight level 313 to flight level 350 was not possible? Sometime after the crash on 17 July 2014 at 1500 hours, the airspace above eastern Ukraine was closed entirely for civilian air traffic. And what is clear and what aligns with the charges, the question that arises, is what was known about the weapons being used in that section of eastern Ukraine. And the Dutch Safety Board has devoted a chapter to this as well, namely what was known about the scope of weapons in eastern Ukraine at the time. The report describes that in this period between the eruption of the conflict in April 2014 and the day of the crash, multiple aircraft of the Ukrainian army were shot, in many cases from the ground. The Ukrainian authorities have officially confirmed some of these incidents. The Safety Board reveals that the military authorities of Ukraine prior to the crash had obtained information that illegal armed units within the area of the anti-terrorist operation had weapons and portable ground-to-air missiles named Ichla and Strela. Shooting and taking down military aircraft by Ukraine was a signal to the military that these weapons were in use.
De militaire autoriteit
The
van
military
Oekraïne
authorities of
onderkende
Ukraine
dat hun
acknowledged that their
militaire
military
vliegtuigen potentieel doelwit
aircraft
waren voor
were a
gewapende
potential
groeperingen.
target for armed
Ter
groups.
bescherming van deze
To protect
vliegtuigen
these
hadden de militaire
aircraft, the
autoriteiten
military
volgens
authorities,
de
according
onderzoeksraad
to the
berekend
Dutch
tot
Safety
welke
Board, had
hoogte
calculated
het
up to
luchtruim
which
beperkt moest worden
altitude the
om hun
airspace needed to be
vliegtuigen
restricted
veilig naar en
for
vanuit
their
het
airplanes
conflictgebied te kunnen
to
laten vliegen.
fly safely to and from
Zij
the
gingen uit
conflict
van een
zone.
maximaal
They assumed a
hoogtebereik van de
maximum
zogenaamde
altitude
manpads,
of what were
de
known
man-portable air
as
defense
manpads,
systems,
man-portable air defense
draagbare
systems, also known
luchtverdedigingssystemen.
as portable air defense systems,
Van
from
4500 meter, 4,5
4,500
kilometer en
meters,
hanteerde een veiligheidsmarge
4.5
erbij nog van 2
kilometers,
kilometer.
and applied a 2,000 meter, 2 kilometer safety margin.
En dan de vraag, wat is nou de
And now the
relatie,
question, what is the relationship,
luchtruim, met de
opening,
kennis
closure of the airspace,
die er was
with the
over
knowledge
eventuele in gebruik zijnde
there
wapens?
was
Wat zegt het
about arms
onderzoeksrapport
and weapons that
daarover?
were being used? What does the Dutch Safety Board say about
De
that?
militaire autoriteiten
The military
concluderen
authorities reached the
uiteindelijk
conclusion,
dat de
ultimately,
Oekraïense
that the
militaire
Ukrainian
vliegtuigen
military
hun
aircraft
vluchten naar en vanuit de
could
gebieden
carry
waar
out
zij
their
missies
flights
hadden,
from and to
veilig
the
op een
areas where they
hoogte
held their
tussen
missions.
6,5
They could do that
6,7
safely
kilometer
between
en
an altitude
7,3 kilometer
between
konden
6.7
uitvoeren.
kilometers and 7.3 kilometers.
Als gevolg daarvan
And as a consequence
achten de
thereof,
militaire
the
autoriteiten het
military
boven deze
authorities
hoogte
felt
veilig voor
that above this
burgerluchtvaartverkeer.
altitude it would be safe for
En
civil
daarbij werd dan nog een
aviation.
extra buffer
And there
tot
was an
flight level
additional
260
buffer
gehanteerd.
that was used up to flight level
De
260.
verhoging naar flight
The
level
increase to
320
flight level
werd 3
320
dagen voordat
was
vlucht MH17
issued 3 days
uiteindelijk
prior
neerstortte
to the crash
uitgevaardigd.
of flight
En in
MH17.
het rapport is te lezen
And in the
dat op
report we can
dezelfde
read
dag,
that on that
14
same day,
juli,
14
een Antonov
July,
AN-26
an
werd
Antonov
neergehaald,
AN-26 was
volgens de
downed,
Oekraïense autoriteiten op een
according to
hoogte
the
van
Ukrainian
6,5
authorities, at
kilometer.
an altitude of 6.5 kilometers.
De Oekraïense
The Ukrainian
luchtvaartautoriteiten
aviation
stelden
authorities
dat de door
argued that the
the
requested
verzochte
increase
verhoging van het
by
beperkte
the
gebied tot
UK
320
SATC
geen relatie had
of
met
the
het
restricted
neerschieten van die
area to
Antonov 26
flight level
eerder die dag.
320 had
Zij
no
gaven daar
relationship,
een
no
andere
link
reden
whatsoever with the shooting of the Antonov AN-26. They
Wat
said that
zijn
there were other reasons
de
for that.
hoofdlijnen geweest van de
So what were
onderzoeksraad,
the
de
main
hoofdconclusies als het om dit
the
onderdeel
main
gaat. En ik
conclusions
zal,
of the
voorzitter,
Dutch
alleen
Safety
even de
Board in this
onderstreepte
respect,
onderdelen
and I will
aanhalen.
only refer to the underlined
De
sections here.
onderzoeksraad zegt
The Dutch
dat
Safety Board
alle feiten en
says that
omstandigheden
all
die
the
zij naar
facts and
boven hebben
circumstances
gehaald
that they were able to
voldoende
uncover
aanleiding gaven om het luchtruim boven het
were
oostelijk
sufficient
deel van Oekraïne
reason
uit voorzorg te
by
sluiten.
means of
Dat is een van de
precaution, to
conclusies.
close the airspace
De
above the
besluitvorming
eastern
over het
part of
luchtruim in
Ukraine. That's
Oekraïne
one of the
werd
conclusions.
gedomineerd
And
door
the
de belangen van de
decision-taking
militaire
regarding the
luchtvaart,
airspace
zo
in
zegt de
Ukraine
onderzoeksraad.
was dominated by the
De
interests of the
Oekraïense
military
autoriteiten
aviation.
namen aan
This is
dat
what the
met deze
DSB
maatregelen de
says. The
civiele
initiative of
vliegtuigen
restraining or restricting
boven
the
flight level
air
260
flight
in eerste instantie
up
die
to
daar
flight level
overvlogen ook automatisch
260
veilig
above the
waren.
eastern part of Ukraine was a decision to be taken by the military
Onderzoeksraad geeft
authorities.
ook aan
The
dat de
DSB
onderbouwing van
also
deze
says that the
verhoging onduidelijk is
substantiation
gebleven
of this
en dat
increase
niet
remained
is gehandeld
unclear,
naar het
and
advies
that
uit allerlei
the advice
luchtvaartrichtlijnen.
in all sorts
De
of
Oekraïense
aviation guidelines were
autoriteiten
not
hielden
followed. The
volgens de
Ukrainian
Raad
authorities,
onvoldoende
according to the
rekening
DSB,
met al
did
deze
not take
maatregelen.
sufficient account of all these measures.
En uiteindelijk
And then
concludeert de Raad
finally,
nog dat de
the DSB
wapensystemen
reaches the
waarvan de
conclusion that
Oekraïnse
the weapon
staat naar aanleiding
systems
van
of
deze
which the
beschikking
Ukrainian
melding maakte,
state reported
inderdaad een
of
risico kunnen
after these shootings
opleveren.
indeed could
En dat
constitute
er dus
a
ten
risk,
onrechte geen
and
maatregelen
that
zijn genomen om
erroneously no measures were
vliegtuigen
taken
daartegen te
to protect
beschermen.
civil aviation, civil aircraft against that.
De opzienbarende keuze, ik ben bij 36,
The
in deze
remarkable
strafzaak om de
decisions,
beperkte
paragraph
sluiting van het
36,
luchtruim
in
niet
this
eens te
trial
onderzoeken,
to not even look into
heeft onder
the
meer tot
restricted
gevolg
closure of the
dat niet
airspace
kan worden vastgesteld
leads to the fact
of
that
de
we cannot
individuen
determine
die in
whether the
Oekraïne hebben
individuals
besloten
that
over
took
de
decisions in
toepasselijke
Ukraine
noodhans
with respect to
op
the
enigerlei wijze
applicable
strafrechtelijk
NOTAMs,
zouden
whether
kunnen
they
worden
in
vervolgd in
any way
Nederland.
could be criminally prosecuted
De
in
vraag
the
die
Netherlands.
daarbij
And the question that
de
rises
vraag is daarbij natuurlijk ook
is
welke
obviously
rol
also
Oekraïne
which
als
role
lid van het JIT heeft
Ukraine
gespeeld
as a member
bij
of
het
the
besluit
JIT played
om geen
in the
om
decision
geen onderzoek te verrichten
not
naar de
to
beperkte
conduct an
sluiting van
investigation
het
into
eigen
the
luchtruim.
restricted closure of its own airspace.
Lezende de eerder door mij aangehaalde
Reading the
Kamerstukken is
parliamentary
dit ook
documents that I
precies het
referred
punt
to
waar
earlier on. This is
Kamerleden kritische
precisely
vragen over hebben
a matter
gesteld,
on which
zonder op
the
die
members of
vragen echt tot
parliament
nu
asked
toe een antwoord te hebben
critical
gekregen.
questions so far without actually getting
Daarnaast heeft deze keuze
an
ook
answer.
tot gevolg
And furthermore, this decision also has the consequence, and this is quite relevant for the duty that we have, the consequence that factually there's still many questions about this restricted closure of the airspace. And all these questions are still outstanding and have not been answered. And in that respect, Your Honor, our conclusion for the moment is that we don't know exactly what happened. It won't surprise you that this subject that I've just touched upon will be extensively discussed on the pre-trial hearing that has yet to be planned or will take place on the 8th of June. So the defense at a later point in time will point out what issues it wishes to have investigated, and the defense will do its utmost to catch up. Because it is at a disadvantage with respect to other parties in the proceedings. But it's very difficult to know how we will proceed. We will keep public prosecution informed of our progress, and we will do our utmost, as I said, to try to give as much information on the 8th of June. Thank you very much.
Stel u voor dat wij gelet op de tijd, het is nu 5 over 3,
Says the presiding judge. I would suggest, since it's 3:05, we break for half an hour. And we give Mr. Langstraat then the floor for the legal assistance team for the victims.